When commercial landlords ask me about accelerated rent provisions, the most important topic of discussion is the requirements that must be met before courts will enforce an accelerated rent provision. Hope everybody's doing well. Let's get right into it. I'm asked quite frequently by Georgia landlords about accelerated rent provisions when tenants default. Let's dive in. There are a couple of issues here. You may know that commercial leases often provide the landlord with the right to accelerate and collect future rents under a lease for the remainder of the term as damages for the tenant's default. An accelerated rent provision typically sets forth an amount or a formula to determine the amount owed by the tenant if the tenant breaches the lease. But you may not know just how carefully prepared accelerated rent provisions must be before they will be enforceable under Georgia law. For Georgia courts to take the action you desire, treating the accelerated rent provision as a liquidated damages provision and enforcing it, you need to make sure the following three requirements are met. First, the injury caused by the breach is difficult or impossible to accurately determine at the time of contracting. Second, the parties intended to provide for damages rather than a penalty. Third, the amount of liquidated damages is a reasonable pre-estimate of the landlord's probable loss. Please hit like if this information helped you. If you want relevant, quick updates and tips every Monday, subscribe to Thomerson Law. We'll be covering more topics like these and other topics critical to know, especially during COVID, each Monday. Stay safe and stay in the know. See you next Monday.